we're going to talk for a few minutes about this United States Court of Appeals decision upholding the jury verdict in a civil case against President Donald Trump, brought by E. Jean Carroll, alleging various forms of sexual abuse and defamation. We're going to talk about this opinion just very generally, just to make you the smartest person in the room. I want you to have a few basic understandings about this case. I don't want to belabor it, but I think you need to know a little bit about it because, again, people are always trying to attack President Trump. And I think it's important to at least understand this case and draw some distinctions between this case and, let's say, the litigation we often see in Second Amendment fights. We'll break it down when we come back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, and member of the United States Supreme Court Bar. All right, folks, so you're probably going to see me talk a lot about this on Fox News over the next few weeks, and that is this Court of Appeals decision out of New York City by the Second Circuit, a 3-judge panel that upheld the jury verdict that was awarded or found in favor of the plaintiff in the case, E. Jean Carroll, a writer who alleged that Donald Trump did various unlawful things toward her in a Bergdorf Goodman dressing room that was sexual in nature, and also when President Trump denied it in various ways, he defamed her. Those were the allegations. This case was tried to a jury, a civil case. Again, this is not a criminal case. No one's going to prison over this. This is a civil case, and Jean Carroll was awarded somewhere in the order of magnitude of $5 million. Donald Trump just took an appeal, arguing that the trial court made a series of evidentiary errors by admitting evidence that should not have been admitted and by denying evidence from being admitted that should have been admitted. So this was kind of the argument that Donald Trump made, and ultimately the 3-judge panel ruled in favor of Jean Carroll. So let's just discuss the basic facts of this Carroll versus Trump case and what happened before we talk about what happened on this appeal. This is how the court explains the nature of this case on appeal. In this case, after a 9-day trial, a jury found that plaintiff appellee E. Jean Carroll was sexually abused by defendant appellant Donald J. Trump at a Bergdorf Goodman department store in Manhattan in 1996. In 1996. The jury also found that Mr. Trump defamed her in statements he made in 2022. The jury awarded Ms. Carroll a total of $5 million in compensatory and punitive damages. Mr. Trump now appeals, contending that the district court, Judge Kaplan, erred in several of its evidentiary rulings. These include its decisions to admit the testimony of 2 women who alleged that Mr. Trump sexually assaulted them in the past, and to admit a recording a part of a 2005 conversation in which Mr. Trump described to another man how he kissed and grabbed women without first obtaining their consent. Mr. Trump contends that these and other asserted errors entitle him to a new trial. That was the question presented, really, and then what happened was the Court of Appeals said in a 3-0 decision that they did not think Donald Trump had a basis for overturning this jury verdict. This is not a big surprise. Why is that? Because the reality is when you're dealing with these kinds of he said, she said situations where there was a debate as to what did Donald Trump do in a Bergdorf Goodman department store dressing room, Jean Carroll testified what he did, allegedly. Donald Trump denied it in depositions. He said he never even met this woman. And there was a he said, she said testimony in front of a jury, and the jury concluded that they believed E. Jean Carroll. Rightly or wrongly, that's what they said. Now, the evidentiary issues here were really quite straightforward. You see, there is a federal rule of evidence that deals with civil cases called Rule 415 that actually allows into evidence, and Congress created this, so don't blame me, don't blame Donald Trump, or don't blame Jean Carroll. Congress created this rule, Rule 415, that says that if you're dealing with a case that involves sexual assault, sexual abuse, and it doesn't have to necessarily be specifically about a sexual assault, it just has to concern sexual assaults, at least that's how the rule reads. Guess what? You can admit instances of allegations or testimony where the defendant are allegedly or potentially had engaged in similar conduct. Now, this is quite interesting because in most cases, you're generally speaking not allowed to admit evidence of a pattern and practice that someone has engaged in. And what I mean by that is, if you accuse me of shoplifting from your store, and I am indicted, let's say, or you sue me, as a general rule, you're not supposed to admit evidence that perhaps I've shoplifted in the past, to say he shoplifted in the past and therefore he did it again this time, because the view historically has been that that kind of evidence is so unfairly prejudicial toward the defendant that it's not allowed in. Even if there may be some probative or beneficial benefits from hearing that evidence for the jury, as a general rule, they considered it so unfairly prejudicial, it's not allowed in. But when it comes to evidence concerning sexual assault, Congress has decided that if there's allegations or testimony or evidence that someone had engaged in sexual assault in the past, it can now be used against them in this particular case. Now, keep in mind, of course, President Trump, as of now, has never been convicted. I'm not even sure he's ever been criminally charged with anything associated with sexual assault or anything of the sort. Nevertheless, this testimony, this evidence that was proffered by two other women that he engaged in inappropriate sexual conduct toward them, was admitted in this case. And the Second Circuit Court of Appeals just ruled that, given the existence of Rule 415, that was allowed, and that was not an abuse of discretion by the trial court for admitting that into evidence, and thus there's not a basis for overturning this verdict. It's sending it back for a new trial. Now, I do want to mention the two women that offered evidence that Donald Trump had misbehaved sexually toward them in the past. That was a woman named Jessica Leeds, who said that either in 1978 or 1979, on an airplane, Donald Trump acted inappropriately, and that evidence was admitted in this case to show that he had done this kind of thing before, the same sort of thing that he allegedly did to Ms. Carroll. And then there was another incident by a woman named Natasha Steinhoff, who testified, or at least explained, that in 2005, there was some incident in Mar-a-Lago where he tried to kiss her or act inappropriately sexually toward her. So those two women, one from 1978, 1979, one from 2005, were allowed to be admitted into this trial, which occurred just a year or two ago. So, it's kind of dated evidence, but nevertheless, it was allowed in, and the jury was allowed to consider it. And obviously, they ruled in favor of Miss Eugene Carroll here. The other thing that came in that Donald Trump argued was not appropriate. And of course, he said that this testimony by Ms. Leeds and Ms. Steinhoff was not appropriate for various reasons and should not have been admitted, that it was so unfairly prejudicial. Remember, all evidence that a party, and this is key to understand, that when you're trying a case, all evidence that someone wants to admit about you, generally speaking, if it's from the other side, is obviously prejudicial. So just because some evidence is prejudicial towards you is not a basis to keep it out, because obviously all evidence offered against you should presumably be prejudicial against you. But what courts try to do is, if something is unfairly prejudicial, then they try to keep that out as a general matter, because it's not fair to the system. It's not fair to the defendant. Here, Donald Trump was basically saying that, first of all, he said that the Rule 415 that allowed certain evidence involving prior sexual misconduct or allegations, or evidence of prior sexual abuse or sexual misconduct, whatever it is, that should not have been allowed in for various arguments. The Second Circuit rejected those arguments, and then the Second Circuit also rejected the argument that letting this testimony from these women about prior alleged bad acts by President Trump was unfairly prejudicial. So even if it had some probative value to the case in helping the jury make a decision, it was so unfairly prejudicial it should not have come in. Likewise, they talked about the Access Hollywood tape, which of course you're all familiar with from the 2016 campaign. That was kind of the October surprise that was dumped out to try to derail President then Donald Trump's campaign, which of course he overcame that and became President Donald Trump in 2016. And of course, the ultimate jury verdict was just recently again, where despite all of this lawfare and all this attacks on him in 6 Ways to Sunday, Donald Trump won again in 2024, which obviously I think is very good for the Second Amendment. But with that said, The debate was also about whether or not this Access Hollywood tape could come in. If you may recall, I'm not going to get into the graphic details here, but basically says that if you're a celebrity, I'm going to paraphrase this as I understand it. If you read it, basically we're saying this: if you're a celebrity, if you're a star, you can basically do what you want to women because they will let you do it, right? He basically saying, hey, if you're like a celebrity, a superstar, you can get away with a lot of stuff that ordinary guys cannot get away with. And he tried to keep that tape out, but nevertheless, it was allowed in by Judge Kaplan. And again, the Second Circuit says, that's probative of a pattern and practice of Donald Trump engaging in this kind of conduct. So it's okay and not an abuse of discretion or huge legal error by the judge to let it into evidence. Now, I should mention that Donald Trump did not testify in this trial, but he was sort of presented, in a sense, to the jury because there was a taped deposition, a videotaped deposition of him, and parts of that were indeed played to the jury. But he never actually came in front of the jury and testified and denied these allegations strategically. That's his choice. You could argue that was good or bad or ugly. Obviously, maybe it would have been better if he had testified. But again, I'm not there. I'm not the counsel for President Trump. They have to make their own choices. And, for the purposes of this case, obviously it didn't go well because Donald Trump lost this case and lost the jury verdict of $5 million. But it probably did hurt him, I'm guessing, in this case, by not testifying. But again, one never knows. It's very speculative. The other thing I want to mention, this is kind of important, is originally Donald Trump was sued by E. Jean Carroll for defamation because he said that he denied knowing her. He denied that he ever attacked her and basically called her a liar. And she sued him in court, claiming that he had defamed her by denying this incident had occurred, this assault had occurred. Now, here's what's quite interesting, and you should be aware of this, that New York State, while this case was pending, now one wonders whether or not this was actually changed in large part because they didn't want Donald Trump to be the president again, and they wanted to hurt Donald Trump politically. But the state of New York, this is the same state where you have Letitia James as the Attorney General. It's the same state where you have anti-Second Amendment Governor Kathy Hochul. It's the same state where you have Judge Juan Marchand and Alvin Bragg and the like, and the same state that went after, Daniel Penny for trying to save people on a subway, right? And that homeless person attack and all that. You're familiar with that case. This is the same state that went out there and changed the law that created a 1-year kind of exception to the statute of limitation for sexual abuse. You see, this allegation against Donald Trump was supposedly occurred, this sort of event involving E. Jean Carroll occurred in Bergdorf Goodman literally decades earlier. So the statute of limitations for suing for sexual assault had already expired. So the state of New York's legislature literally enacted a law that created a 1-year exception to allow the rejuvenation of civil claims about sexual abuse to be brought, even though they had previously been barred by the statute of limitation. This is what the Second Circuit said about that change in the law in this opinion, which I'll put a link to in the description below of the court's opinion. While the Carroll lawsuit number 1 was pending, the state of New York passed the Adult Survivors Act. The Adult Survivors Act provided adult victims of sexual abuse with a new 1-year window in which to sue their abusers, even if an otherwise applicable statute of limitations had previously expired. In August 2022, Ms. Carroll advised the district court that she intended to sue Mr. Trump for damages for the alleged rape once the ASA's window filing opened on November 24th, 2022. So in light of that change, the 1996 alleged sexual assault between E. Jean Carroll and Donald Trump in that Bergdorf Goodman department store was no longer barred by New York statute of limitation because New York had created that 1-year kind of grace period for barred claims to basically be brought. So Jean Carroll at that point added to her defamation lawsuit the additional claim for sexual abuse, sexual assault, whatever you want to call that particular law here. And that's what happened. And I should also mention one additional thing, because we've talked about Rule 415. This is the text of Rule 415 that really says that indeed, if there's testimony that you had or evidence that you previously engaged in sexual misconduct or sexual assault, that can be used to show that you engaged in sexual assault in a particular case. This is, as a general matter, the reverse of the traditional rule that says that character evidence and prior evidence of misconduct is, generally speaking, so unfairly prejudicial that it's not allowed in the case. This is kind of an exception for sexual abuse cases. Whether you like it or not, or think it's a good or bad rule, again, this is what Congress has decided as a matter of public policy, and whether or not you think this is good or bad under the due process notions of allowing other bad acts to come into a particular case, that's not for me to decide, but this is what Congress has decided, and let's look at the rule that they came up with right here and right now. Rule 415, evidence of similar acts in civil cases concerning sexual assault. In a civil case in which a claim for damages or other relief is predicated on a party's alleged commission of conduct constituting an offense of sexual assault, evidence of that party's commission of another offense or offenses of sexual assault is admissible and may be considered as provided in Rule 413 and Rule 414 of these rules. So that's what Rule 415 says. Now, I should say that Donald Trump actually offered some pretty good testimony in his deposition about why this could not have occurred. He pointed out that any notion that he would have done something in a public department store, Bergdorf Goodman, that was very busy at the time, the notion that no one would hear it or that, and no one would come to their aid, he just basically indicated that it's not credible. This allegation by E. Jean Carroll is not credible and is unbelievable, but nevertheless, he did not go to trial, look the jury in the eye, and testify, because at the end of the day, keep in mind that when you're dealing with trials, and this is different than the Second Amendment context, because in the Second Amendment context, we're really talking about questions of law. What does the Second Amendment mean, and how does it apply to a particular case? You don't usually have questions of fact about who said what when in Second Amendment cases. So this is a dramatic change, because when you're dealing with trial cases, issues about questions of fact, did he go through the red light? Was he drunk? Did he do it? Did he commit the murder? These are questions of fact. And who decides the questions of fact? Well, usually the questions of fact are decided by a jury. And when a jury comes out and says that they find as a matter of fact that Donald Trump had committed illegal acts against E. Jean Carroll, that finding by the jury is entitled to tremendous deference by not just the trial court, but by the appellate courts. And unless you can show that some of the evidence that the jury considered or failed to consider or was not allowed to consider somehow would have altered the result in a big time way, then usually the appellate courts are going to uphold civil jury verdicts, because they just say, hey, the evidence was proffered, the lawyers did their arguments, the trial was generally good enough, and the jury made a decision based on the credibility of the testimony of the witnesses. And unlike the Court of Appeals, that's not going to meet any of the witnesses, they're not going to meet experts, they're not going to be in the room, they're not going to watch jurors, they're not going to watch witnesses fidget or roll their eyes, they're not going to see any of that. And therefore, basically, the appellate court in this case, which is typical in all cases when you're dealing with questions of fact, will say, we're going to defer to the views and the findings of the jury, because they were there, they met the witnesses, they saw the experts, and therefore we're going to basically trust in their decisions, because that's why we have a jury system, to assess the credibility of witnesses. And in this case of a he said, she said, Jean Carroll testified for 3 days. They obviously believed her testimony. Whether it's right or wrong, that's not for me to judge. It's up to the jury, and that's the point of the Second Circuit. They're not there to second guess what happened. I'm not there to second guess what happened. It's up to the jury to make that decision, and anyone can second guess anything, but at the end of the day, the jury makes the decision. It's largely deferred to, and they found that this is what happened, and they awarded that $5 million award. So there you have it, folks. Hope you learned something here today at the Four Boxes Diner. Make sure you follow me at Four Boxes Diner on X, and I look forward to talking to you again real soon here at the Four Boxes Diner.
Orders up. Table 2A.